James Thomas on behalf of Mr. Radcliffe.
I didn't know Johnny on behalf of Mr.
Strenuous, the court did not permit you time to go through the transcript. I get a little bit sick and tired of that because the court has tried to provide everybody an opportunity to bring whatever issues it can before the court. And for you to say that the court did not provide you opportunity to go through a transcript, not in terms of a transcript, because one was not prepared, nor did you demand one. In fact, so that the record's clear, you requested of my staff a video of the proceeding. You requested that on Tuesday, the 25th. That video was expedited by my staff and given to defense counsel. Really should have been put in and there so that that's not an issue in the future. I think that that is more than adequate time to prepare it.
Thank you, Your Honor. Your Honor, for the record, I would like the record to reflect that we did not receive the state's response till after 5 o'clock on Monday, as the court directed that we should have received it before 5. Regardless, Your Honor, I would like to.
That caused you any prejudice?
Your Honor, I'm just placing it on the record.
No, but has it caused you any prejudice?
In a sense, Your Honor, it had, because if we received it before 5 p.m., then that would have given us more time to evaluate the state's position. But we understand and we
position, counsel. Another disingenuous argument. Go ahead.
Your Honor, the state conceded in their response that Mr. Radcliffe falls within the first category of criminal liability under the statute and under People versus Atkins. That category is causes or knowingly allows a child to engage in child activity for the purpose of producing any child material. The state's theory is that Mr. Radcliffe did this by encouraging the alleged victims to make masturbation videos and email them to a Yahoo email or upload them to a Snapchat account provided to Trooper Ryan by the alleged victims. Your Honor, under People versus Willis, the Supreme Court in their order 1574652 stated, only as it pertains to this group, the first group, as I indicated earlier, must a person act for the purpose of producing any child of material in order to violate the statute MCL 750.145C2. The state has failed to elicit any testimony showing the probability that the coercion of child sexually abusive activity was for the purpose of producing any child defined as child abusive materials defined as a developed or undeveloped photograph, film, slide, electronic visual image, computer disc, or sound recording of a child engaging in the list of. We agree that the act that's elicited here or that the state concedes is mass as well. The state conceded that no evidence of child abusive material was testified to and relies on evidence still being processed. This court cannot consider evidence that has not been presented. Evidence that it's at a crime lab still being evaluated is not evidence that was presented at the preliminary exam. The state also relies on two cases, People versus the state relies on People versus Sturza. They indicate in those cases that the court affirmed the conviction. Your Honor, in that case, the defendant, the theory of guilt presented by the state was that the defendant fell into the second category or even the broader third category. Your Honor, in addition to that, when we look at the jury instructions for child abusive activity causing or allowing, that requires some form of material. As I presented that definition to the court, that element is needed under that jury instruction that the child material be a picture, movie, or illustration made or produced by any means. No evidence of that form of material was presented in this court during the preliminary exam. Probable cause requires a quantum of evidence sufficient.
It's not true, is it? I mean, you have the testimony of these 9 witnesses, or at least 7 of them.
That is correct, Your Honor. But in the end of those, none of the testimony referred to actual material as is defined under the statute. Material requires a photo. They're developed or underdeveloped. It could have simply been undeveloped negatives of images. Nothing of that line was presented during testimony. Trooper Ryan testified that he reviewed a camcorder and 7 videos that came with it. None of them contained any material that was child abusive material or child activity. He testified that his first Snapchat warrant came back and had nothing that supported that form of material. He testified that Google came back and found nothing from the witness Weston's Google email address that supported child abusive material. He also testified that Yahoo came back in relation to the Yahoo email address that was provided to Trooper Ryan from one of the alleged victims, that nothing came back from that address. Nothing was testified to during preliminary exam that meets the definition of child sexually illicit material. And given the fact that the state has conceded.
If a witness says, I produced this movie, and this movie falls within the definition, you're saying that's not enough.
Your Honor, that is correct.
That's the case I was looking for,
So,
and where I don't have one.
So, Your Honor, the Supreme Court indicated in their order in Willis that that's a question that's being presented here. Here, we're asking this court to look at statutory interpretation. When we look at statutory interpretation, we first look at the plain language of the statute, whether it's ambiguous or not. In Atkins, the court looked at that statutory interpretation, determined that because of the first form of criminal liability does not have an or between child abusive activity or child material, it requires the form of material. If the state had made any other argument, then we would have a different conversation. Here, the state's theory in this case is that Mr. Radcliffe coerced, encouraged victims. That falls under the first prong, the first form of criminal liability. Therefore, the state has to produce a form of material. That prong is to protect the community from production of child pornography. If their argument is that that is what he did here, the law requires them to present a form of material. The court may ask for a case on point, Your Honor, but we know how cases on point are created. They're created by these forms of challenges. So that is why we're bringing this challenge before the court to evaluate this case, listen to the state's argument that they are placing Mr. Radcliffe into the first category of criminal liability. The state has lifted that. They indicated that in their response. They conceded to it. So therefore, they are required to present some form of child material to fulfill that criminal liability portion under that first category. For those reasons, Your Honor, we ask this court to deny illicit activity, charges that are associated with aggravated abusive activity, as well as charges associated with using a computer or internet to commit those crimes. We also request this court to deny bind over on the other counts, count 1, count 5, and count 33 of this case, as discussed in our last day of preliminary exams.
Response.
I listened to counsel state that the statute requires some form of material. The state has to present a form of material. They are required to produce some material. What counsel is asking, Your Honor, to do is to rewrite the legislature and add an element to the crime that doesn't exist. They keep citing to the order in Willis, and it's an order. The defendant's application for leave to appeal for his conviction for child activity was denied by the Supreme Court. Provide a synopsis of the child abusive activity and the definitions therein, and indicate that the defendant has nonetheless raised pertinent concerns regarding the breadth of the statute that may warrant further review by the legislature. So I don't think I need to tell counsel that this is not the legislature. This is a court. The standard before the court is whether there's probable cause that a crime was committed and this defendant committed it. And that's the standard here today. To write something in a pleading to Your Honor that she didn't have time to obtain a transcript, or somehow she's unfairly disadvantaged. There's nothing in that transcript that would indicate that we have to produce child abuse. And we're not conceding. I didn't concede that there was no evidence of CSAM. Every single one of those victims testified to the coercion, the request, the sort of grooming of the defendant in obtaining this CSAM from them. He gave them the address. He told them how to do it. He critiqued the videos. So there are no physical videos at this time, but there was evidence about those videos. They all uploaded it to the address he gave, to the Snapchat he gave. So I'm not conceding anything. There is no requirement. Counsel argued before Your Honor on Tuesday, the 25th, that there had to be a video. Your Honor gave her a break to go get that case law and then an adjournment until Friday. The case law doesn't exist. There's no recording. All of these victims came before Your Honor and testified to the grooming that happened by this defendant. He coerced them into making them feel like this was a normal thing for a 15-year-old boy to on a video and send it to their mentor at the church. He made it seem normal. He coerced. He allowed them to do it. And they were all under the age of 18. The fact that my response to her, whatever that was she filed on Friday, because it wasn't any case law to support her point, arrived at 5:06 p.m. She claims she's disadvantaged. I mean, this is really, really unbelievable. And so I would just ask, Your Honor, the evidence for all of the counts, for each of those victims, they engaged in child activity by getting naked in front of a phone, their cell phone, and they did that at the request and coercion of this defendant, and then they sent it to him on Snapchat, on email. And so there's no requirement that those videos be recovered. That can be an issue for the trial. She can make that argument to them, that there's no video, so this didn't happen. And that's going to be for the jury to decide. And so we would ask that you bind over on all of the child activity counts. There's one for each victim. And I suggest to this court that this case law suggests that for each victim, I could charge one for each video they made. So there could be multiple counts for each victim. And the CSC 1 charges with the victim Cole and with the victim Jacob. The testimony was very clear before this court that the defendant held a position of authority in the church. That's how he met both of these victims. And again, it is our position that he groomed them. And Cole was under 13. And I'm saying his name Cole. I believe that his testified that he was under the age of 13 when multiple penetrations occurred. He turned 13, and total in all, he's estimated 15 penetrations under the age of 16 at the defendant's residence when he met him at the church, when he was in a position of authority over him at the church. So there is definitely probable cause that those 6 counts of criminal sexual conduct in the first degree were committed, and that this defendant committed those. As well with Jacob, he testified to—
If I may stop you just for one moment. On the issue regarding Cole or Christopher, there are 6 counts. Are the 12, 13, 14, are those in 17 or in addition to?
No, Your Honor. The 3 counts of CSC with a person under the age of 13, those are the penetrations that occurred when Cole was 12 years old.
Gotcha.
There's no showing that I need to make that he was in a position of authority, just that he was over the age of 17 and that the victim was under the age of 13. And those 3 charges carry a mandatory minimum 25-year sentence if the defendant is convicted. The additional 3 counts, the penetrations for Cole, would occur when he's 13, 14, or 15, and the defendant is in a position of authority at the church.
Got it.
So although Cole testified to 15 penetrations, I have charged only 6 of those. 3 when he was under 13, and 3 when he was between the ages of 13, 14, and 15. And the defendant was in a position.
Asking is, like you said, with the individual events on the CSAM and aggravated CSAM, if the testimony were to reveal the people, and the court heard the proof, believes the proof, could add counts.
Yes, absolutely.
And so part of my reason for asking, because I'm still trying to make a determination of this, if those are pled in the alternative, that would be a potential of really 24 counts, but 12 that he could be convicted of. If not pled in the alternative, then given the testimony, there could be an additional 9 counts, starting with the 15, 3 specific to 13, but there always is this relationship issue.
Correct.
Okay. Right.
So I do believe certainly for probable cause level that there is sufficient evidence to bind over on the penetrations for the victim identified as Christopher that I'm now calling Cole. Additionally, the CSC counts for the victim identified as Jake or Jacob. He testified to two very distinct penetrations. One occurred when the defendant, of course, was in this position of authority, had access to that victim at the church when he was 13, 14, or 15. The first penetration occurred in the vehicle. The second penetration occurred the following summer in the defendant's vehicle in the church parking lot, both located within Washtenaw County. And I believe that there is sufficient evidence that he was in a position of authority. That's how he had access to Jacob. He still continued to see him at the church. And again, in line with the defendant's sort of grooming of all of these young men, he friended him on Snapchat, knew victims snuck out of the house for the defendant to suck him not once but twice. And so we would ask that they also testified they did and sent to him. He also paid them for it. I mean, he really fits in all 3 categories because he financed this. He paid them money. He bought them items. So we would ask that you bind the matter over to circuit court on all of the counts contained within the felony information, with the exception of count 1, 4, 5, and count 33. We did not hear testimony on those counts, and so we would not be moving or bind over on 1, 5, and count 33.
No further defense.
In response to the state's position, you heard the state indicate coercion again, indicating that their argument is that Mr. Radcliffe coerced these individuals into making the videos. The defense is not trying to rewrite.
Counsel, under the statute, would that matter?
It does, Your Honor. Under the statute, coercion falls under the first criminal liability under Adkins. That is case law. It is case law presented by the Court of Appeals that divides criminal liability under the statute into 3 categories. First, being the coercion piece, persuasion. That category is what they have put Mr. Radcliffe in, and that category requires the form of material or for the purpose of producing a rewrite law here. We're trying to refresh the court's memory on the fact that interpretation of the law has been made here. Atkins created 3 criminal liability categories. The state chose their theory of guilt. They chose how to ask their questions. They presented that evidence and presented a theory of guilt based on coercion. They placed themselves in the first category under Atkins.
So that,
if I may, Your Honor.
it certainly can be addressed in terms of coercion, but go ahead.
In addition to that, Your Honor, Mr. Willis didn't fall under the first category. The defendant in that case fell into the second category. There was proofs presented that dealt with arrangement or attempting to make arrangements. In addition, the same goes with the case that they relied to Sturza. In that case, category 2, maybe even category 3, broader. In that case, there was arrangements. There was testimony that was pulled that dealt with that information. Here, the state didn't have that theory argument. They're saying, well, he could be under every category. Your Honor, the state chose their theory of guilt. They presented their theory of guilt, and that was coercion. That was encouragement. That was the allegations that Mr. Radcliffe told them about this as an idea, right? That's what led to the actions. The state also says in their response that Mr. Radcliffe requested. He didn't request this information. There was no testimony of that. Many of the victims indicated that he suggested the idea. They did nothing because they felt it was awkward or inappropriate, but later chose to reach out to him and ask if they was still an option. That's not a request that was testified to. That was an idea that was presented and a victim choosing.
An idea presented to a 13-year-old.
And that would fall under the coercion encouragement. Your Honor, the court defines encouragement as if I may, defines encouragement as to attempt to persuade the case that the state is relying on. So if that is encouragement, That's the idea that was presented. That places Mr. Radcliffe in the first category by the actions of the state. Therefore, the state has to meet that burden of presenting material here.
But you're making that up about material. Again, give me a case that says that. I'm not here, hold counsel. I'm not here for some like educational experience of statutory interpretation. I'm not here to do that. We have the law that we have. And you may not like it. There are plenty of laws that I have to enforce. I may not like.
That is correct.
But I can't go just making up new law. That's not my job as a judge.
Your Honor, the law is the statute. Am I correct on that presumption?
I don't answer your question.
The statute has been broken down in Atkins case law presented to this court in those three categories. That's case law, Your Honor, that we are presenting to this court. Unless the court can find.
None of that says they have to have the material.
Your Honor, Atkins indicates the three categories. The case of Willis uses those three categories to define the requirement for material.
You keep saying it doesn't make it true.
Your Honor, that's what the case law says, that Willis.
You keep saying it, doesn't make it true, counsel. You can say it over and over and over and over. And it doesn't make it true. I've asked you for it. As Ms. Reiser points out, gave a break, present it to me, gave time, present it to me. Not there.
Your Honor, am I understanding the court to indicate that the case of Willis does not present that there are.
You interpret that and try to twist it, that's your business.
Your Honor,
I think I'm real clear in what I'm saying, because I don't think anybody has said I'm not clear. When I say
Your Honor, our position is that the state has presented a theory of guilt based on coercion, which puts Mr. Radcliffe category under Atkins, and under Willis requires some form of material. That is our position as the defense.
Anything else from the people? Mr. Reiser?
No, Your Honor, thank you.
All right. Court's going to take likely exactly 10 minutes. I will come back with my decision argument. Court stands in recess.
All right.
Back on the record in the case of the people of the state of Michigan versus Zachary Radcliffe. Counsel is all present. Court, in attempting to try to make a determination or bind over in these cases, and court will not, of course, bind over on counts 1, 3 as the complaint now stands, given that there was no testimony, so we can get that out of the way. But let me just say at the beginning, this is a probable cause hearing. This is not the trial. I've given, certainly in this court's mind, every opportunity for counsel to present whatever they wish before this court for this court to consider. Some say maybe bending over backwards to make sure that all of the information gets to me. But one of the things that I said at the end of the last proceeding when I adjourned for the filing of briefs, and there was a loud exclamation coming from that side of the courtroom because it was being adjourned, and I did not take offense at that. But one of the things that I stated is that, and I was going to take and do whatever I could to make sure that got it right. I owe that to the alleged victims in this case. I owe that to Mr. Radcliffe. Sometimes, as I stated, that we often or sometimes can end up in situations where the law says something. We may not like that law. We may not like the way that it is laid out. But I'm not here to create new law. I take the law as it's written by the legislature, take the interpretation either that higher courts are given to the law and otherwise. There is nothing that this court sees that requires that physical piece of evidence. Argue that at trial might be a good argument at trial, might be a successful argument at trial. But at this stage, that's not what it is. I listened very closely to the testimony of of 9 young men about their version or their view of what they had been through. And let me just say, so that it is very clear on the record, that as I listen to each one of them, not only is their testimony before this court compelling, I found their testimony exceedingly credible. Each one, in their own way, at various times as they were testifying, were recounting things that, quite frankly, for them, was extremely painful. And you could see it on their faces, you could hear it in their voices. And to a man, when asked a question where they maybe could have made something up, they didn't. They said they didn't know. They weren't trying to mislead anybody in this court's mind. They wanted to be heard. And they great, for some of the witnesses, at great pain to them to try to recount it. But I will say this also about them. And while I say that their testimony was compelling and extremely credible, every one of them was courageous. I don't know that there are many people that, having gone through what they testified, would be able to stand before any court or any place and say those things. With some of them, it was very hard at times. I will be free to admit it. Watching as they're relating what had transpired, and at the same time seeing in their eyes and watching their expressions as from what they're telling, because that's probably how they've had to live their life and sort of separate out this whole series and times from who they are now and progressing. But one other thing that I noticed about all these young men, to a person, they were almost saying that it was over in a way, because every one of them, I watch very carefully. People don't think I see things, but I see everything in this courtroom. As they're telling their story, they're looking the defendant right in the eyes. They're not backing down. They came here to said that you kind of go and you just get the job done. And he was particularly Weston. You could tell it was very hard for him. I think it was hard for all of them, but it was hard, particularly for him, to go through that. I wanted to make that very clear on the record in terms of this court's perception of all of the victims as they testified, because I think that's important. It's important, and I'm not going to be the final decision maker on this case. That will likely rest with some jury. But what I saw with them, they need to be believed, and they ought to be believed. That's maybe for the future. But I believe them. I believe everything they told this court. Having said that about the victims, I also now turn, because I think it's important to understand at least the court's view of the context of this case. I don't say this lightly at all. Not how I operate my life, and certainly not how I operate as a judge. but in my 25 some plus years, I've seen a lot. This ranks up with one of the most egregious predators that I have ever seen as it regards individuals. As you listen to each one of these young men tell their prosecutor, so you could hear the emotion in what she was saying, I don't know that grooming really defines it, but it is a grooming. It is just this molding of these individuals to sort of succumb to his will. And counsel talks about the issue of coercion. Coercion can happen in a lot of different ways. Sometimes it can happen directly, sometimes it can happen indirectly. These young men in this court's mind were coerced, but it's not going to be you do this or else. That's the most direct form of coercion. This coercion was more insidious, and I put this idea in your mind. Then I come back to, and almost that circumstance where, as defense argues, but I don't agree, that it almost becomes these victims' idea. One always has to remember, however, and I don't like using this, but I allowed it to be said in the courtroom because I don't allow disrespectful things to be said about people or groups of people. Remember to entice some of these victims. The defendant perpetrated a story to them of the Japs. And I don't like saying that, but when I first heard it, I thought I had been dumped into a 1940s World War II. But many of them kept saying that that's what he said to them. So that it wasn't him getting this and giving the money, it was some other people. Fear to say, I don't believe, when I listened to everything and analyzed this case in my mind, that those people that he said existed ever did exist. Regrettably, I think that there wasn't anyone financing this, as exemplified by what Isaiah was given and what Ian testified to, that it was a church that paid for it. Sad to say, but I think that's what happened. That iPad, those headphones, so that one can recall. And then it was Ian, who worked at the Apple store, that provided the information that was paid for by the church's credit card. So that racially derogatory term that the defendant was using with these young boys, those folks didn't exist at all. I don't think. In this case. But part of his grooming, he was incredibly and remarkably consistent with these individuals. There was the money, not just the money that was paid for the videos, but there was just money given to these young people. All of these things that anybody that has ever been around teenagers know are enticements to them. And all of these things are done. And one of the things that also is a bit remarkable is that he would take them to the movies. There's no allegation that anything necessarily occurred there, but I have my suspicions as to why he chose that particular theater as opposed to another one. There are two others around here that certainly they could have gone to. The coercion that's created, the sort of false image, this sort of grooming, and all of this mixture of stuff, based on the testimony before this court, this defendant perpetrated these acts against these children at the time under his auspices and as a mentor to them, as almost family to them, and as somebody that was supposed to be teaching them. He used all of that to manipulate these young boys in this court's mind to do something that they would not ordinarily have done. With reference to the specific counts, I'm going to lay them out this way with sort of go victim by victim so that we can try to keep this clear. With regard to Isaiah, referencing counts 8, 23, and 24, his testimony, indeed, that this court found credible, reveals that the people have sustained their burden in trial on those counts, 8, 23, and 24. There is additional testimony that there were, as the people have suggested, other videos not charged, but this court has the authority to add charges where this court believes that the evidence suffices to add charges. So while I will sum it up momentarily, the court is adding 3 to the specific allegations regarding Isaiah. The court is adding 3 counts of CSAM to the charges. With reference to Noah, in regard to Noah's testimony, going through and the court having found his testimony credible to what was done and how this individual, Noah, was called upon to make these videos and send them off to specific locations, which the defendant had given to him, and that with all of these individuals, he induced, enticed, otherwise encouraged the production of these things. That's clear. I'm finding that regarding all of these. But specifically regarding Noah, that being counts 9, 25, and 26, court finds that the people have indeed sustained their burden with regard to the charges listed in the complaint. The court is adding 3 counts of CSAM to. Regarding Maxwell, the testimony of Maxwell also clearly indicates that he would take them to movies. There was a football, watching the football game, going to the Imagine Theater, and that he encouraged and enticed Maxwell to engage in these acts to then send the videos off to him, and that particularly regarding him and others who would receive payment for these videos. In that respect, there were 20 to 30 videos that were testified to as the number of times. The court, realistically, at least 20 should be added, but the court will add 3 additional counts. So the court, make that clear, the court would find that the people have sustained their burden as to counts 10, 27, 28, and there will be 3 additional counts as it regards Maxwell. For the time, I'm going to skip Cole or Christopher and Cole and get to Jacob. It is not contested as it regards Jacob that not contested, nor was it argued on bind over regarding the testimony of Jacob, which the court found very compelling. And the court would bind the defendant over to stand trial on counts 29 and 30, the people having sustained their burden. With regard to Weston, again, his testimony before the court was very similar to the others in that he would testify that he was like a brother to me, that they communicated through Snapchat, and that he was going to make money for the masturbation videos. Also, that he would be taken to the movies and the like. It's also interesting with regard to that he gave the same email address that numerous of these victims gave them the same type of instruction. There were 15 to 20 videos that it would be $80 to $100. He would get more, between $200 $250 if he showed his face. And it's consistent with the other victims in this case that there would have to be the high-pitched, almost female moaning that would have to take place. So with regard to Weston, as regard to the charges contained in count 3, 4, and 6, the court does find that the people have indeed sustained their burden. As to those counts, the court would add 3 additional counts of CSAM as it regards Weston. With regard to Ian, and again, Ian's testimony was the same, but a little bit different in certain respects, because notion of what happened to the iPad and the headphones, and knowing that they were paid for out of the, or by the church card. His arrangement was, I won't say somewhat different. It was all, these were all sort of cash transactions in some way, some cash going one way, some cash going another way. But in listening to that, he had specifically testified that he would, if he sent the videos, and this is where Ian's gets a little bit different, he would send the videos, he would get a discount for basically studio time or production time. And specifically testified that if the $1,500 would be as forgiven or paid for. It was a bit hard to listen that he was actually paying $1,000 to someone, and then this person was doing this to them. It just incredible in my mind that he would do that. But he testified that there were 20 to 30 videos that were sent, also given specific instructions as to what to do. Court would find as to Ian that the people, with regard to counts 18, 19, and 20, people have indeed sustained their burden, probable cause, and the court would find it as, along with three additional charges of CSAM specifically related to Ian, him testifying that there were 20 to 30 videos. There was then Reese, and Reese specifically had testified about the Snapchat 2014, and that he had been there. He was very specific in terms of this particularly time frame, but that this was a bit different than the others because he was supposed to get paid but never did get paid. He was a lot like, I believe it was Maxwell, who really never saw any money. The defendant was holding his credible because that was the trust that he had engendered to these individuals, and broke that trust. One never knows whether it was ever intended upon paying these individuals. But after listening to the credible testimony of Reese, the court would find that as to those two counts, 31 and 32, that the people have indeed sustained their burden. With reference to those counts, the court would indicate that Reese testified that there were 30 to 40 videos. The court would add an additional 3 counts as it regards CSAM, as it regards Reese. As it regards Devin testified 7, 21, and 22. And he looked at the defendant as an older brother, brother figure. Many of these individuals sort of manipulated at times into believing that this is what young men do, and so therefore, and what brothers do regarding that. His enticement at times to some of these individuals was sending the video himself, knowing that it had to be returned or should be returned because he created this image of this happy come day. Okay. Specifically with regard to Devin was asking for pictures with face and behavior and manipulation that is just prevalent through all of these victims. Testified that there were 30 to 50 videos that transpired. So with regard to Devin, the court would find that the people have indeed sustained their burden as it regards count 7, 21, 22, and would bind the defendant over on those charges, and would also bind the defendant over on an additional 3 charges of CSAM. Going back to, and so that the record is also clear, given the number of videos testified to, the court would also bind the defendant over on count 2 and count 11, that the court would find that the people, based upon the testimony of the victims, had those charges were committed. This defendant committed those offenses. Going back to Christopher and or Cole, also known as Cole, there are 3 counts of CSE first degree for someone under the age of 13. With specific reference to Christopher's testimony in the case, and it was, again, a circumstance where he would buy for Christopher clothes, shoes, all part of a grooming process, all part of that. But another issue, which isn't uncommon for teenagers, but one thing that he was testifying to was problems that he was having with his mother, and that this defendant, according to his testimony, was there for him. And so having problems at home, that he would go with this defendant. He also then entered into this game with Christopher about these bets about eating food, and then would have to enter into an oral sex act of sucking his, and then he had to uphold his bet. It's this, again, that manipulation of these individuals. Upon direct examination, when asked how many occurred, Christopher was very specific. He said it 15 times that occurred. Whenever he tried to, I guess, pull away in some way or not do something, he was very specific that the defendant would cry and say he's breaking his heart and those kinds of things. Obviously, sort of trying to play to Christopher's good nature that Christopher would then just give in so that this other person, no matter how much pain I guess Christopher was in, wouldn't be in pain. And then specifically asked, after examination, I specifically asked Christopher, again, how many times? And he repeated specifically to the court at the court's questioning that it was 15 times. I believe him. I believe that he was put into sort of, for him, for Christopher or Cole, an impossible position. And that it occurred 15 times to him. So as it regards the counts 12, 13, 14, 15, 16, 17, those 6 counts, the people have sustained their burden, showing that the defendant, that these offenses were committed and that the defendant committed these offenses. And so the court would bind the defendant over on those charges. The court is adding nine counts of CSC in the first degree regarding relationship, those specifically related to Cole and specifically related to his testimony. So that the record is clear, all counts with the except that are listed on the initial complaint, with the exception of 1, 5, and 33, the defendant is bound over to stand trial on. With reference to the particular 7 individuals, those would be those that testified, excluding Jacob and Christopher, there will be 21 counts of CSAM added to the complaint, and then 9 counts of CSC in the first degree related to the complaint. So as I have it, counsel, there would be a total of, we started, I guess, with 30, 33. There are 3 that are not bound over. The defendant will be bound over to stand trial on those 60 charges.
Thank you, Your Honor. Now have a new information prepared prior to the first pretrial in circuit court. As a housekeeping matter.
Are you going to talk about the numbering?
I am going to talk about the numbers, or should I just?
Well, what's going to end up happening, our system, the numbers ended, and we went through this before, the numbers ended at 33, right? Oh, they're not going to, okay, let me put it this way.
So should I?
As to the numbering that the circuit court will take the filing on, I can't get into that. What I will say is that my Carroll or Register of Actions will indicate successive numbers as I've laid them out during this discussion, starting at 33. So starting with 34.
So 34.
34 all the way up.
Got it.
So it will really end up with 63, but 3 will not be, are not bound over on. Unless I hear anything further from either side, defendant's bond will continue as denied. Thank you.
Thank you.
All right.
Huh? Oh, I do have to set a pretrial date. Everybody,
Everybody understand mute?
well, are you waiving presentation of the information at this time?
No, Your Honor, given that there's going to be amendments made, we do want clarity on the presentation of information.
Okay, well, Mr. Reiser, as the district court does it, the circuit court can do it. How soon can you have the new information?
I can have it prepared by tomorrow. Do we have to stay here then for the arraignment on it, since they're not waiving the information?
Well, I can send it up, but I'm not going to do that. I'm not going to do that to my fellow judge in circuit court. They don't want to waive presentation of the information for those reasons, then you'll come back to me. If you want a formal reading of it, then I will read all 60 counts. So If you can have it, I'm here all day on Thursday. I'll set it for Thursday at 3:00 for arraignment on that.
Thursday at 3.
Thursday at 3.
Your Honor, do we have permission to appear via Zoom? Both
No.
myself and Mr.
Nope, you're gonna be here. You're gonna want, I know the reading of it, and you're gonna hear every word
Your Honor,
of those 60 counts.
Thursday will not work for myself, and I don't believe it'll work for Mr.
I'm
Thomas.
setting it for Thursday on the arraignment.
We already have a prior court.
I'm
At 2
setting
o'clock.
it for Thursday on the arraignment.
Your Honor, I'm indicating to the court that we won't be able to be present for that on
I-
Thursday
I-
unless the court's
I-
going to allow
I-
us to via Zoom.
I'm not allowing appearance via Zoom.
So you'd like us,
You want to appear tomorrow night? I'll be here.
all right, Your Honor.
Tell me when you want to be here.
Your Honor, we're just not available to,
When do you want to be here? And then I'll work it into my court schedule. You got Wednesday, Thursday, or Friday. Take
we're
your
able to
choice.
do Wednesday, Thursday, or Friday if the court's willing to do Zoom so that we can appear.
I am not going to do Zoom.
Then we would ask for Friday, Your Honor.
I'm going to do it on Friday.
4 o'clock.
4:00? 4:00 Friday. And then at that time, council, I'll give the pretrial date once we have that. Thank you. Court stands adjourned.
O'Brien's.